in our mind. Let us show how a judge can pronounce judgment at once as mandated by law by taking some concrete examples. Suppose a suit based on a promissory note is being argued. Only two issues are framed, which are: one, whether the execution of the suit promissory note is true, and two, whether the suit promissory note, if true, is not supported by consideration. The plaintiff's advocate should argue briefly that the PWs 1, 2 and 3, who are the plaintiff and the two attesters, have consistently deposed about the execution of the promissory note. If the plaintiff's advocate tries to waste the time of the court by reading the entire depositions, the judge should immediately curtail him, saying, "Mr. Advocate, confine yourself to the consistency of evidence of the witnesses of the plaintiff without reading the entire depositions unnecessarily." Once the advocate briefly states the gist of the evidence of the witnesses, saying, "Your Honor, plaintiff's witnesses have consistently spoken about the due execution of the promissory note," the judge may note briefly in his notes paper that PWs have spoken consistently about execution. He must then ask the defendant's counsel to reply to the plaintiff's submission. If the defendant's advocate does not contradict this or bring out the inconsistencies or deficiencies of the plaintiff's advocate's submissions, the judge need not, and I dare say, should not read the entire evidence led by the plaintiff. He can instantly, that is at once, as prescribed by law, conclude that the execution of the promissory note is proved, as the defendant did not point out the inconsistencies on this issue. On the contrary, if the defendant's advocate tries to blow out of proportion the contradictions in the versions of the witnesses of the plaintiff, such as, "Your Honor, PW1 deposed that the promissory note was executed at 10 a.m. and PW2, who is the attester, deposed that the time of execution was 5 p.m. or, "Your Honor, PW1 deposed that one and the same pen were used by him as well as the witnesses, whereas PWs 2 and 3 deposed that they used different pens for signing, and the witnesses were deposing after a gap of some 5 years from the actual date of execution of the promissory note," the judge is entitled to draw a presumption under section 114 of the Evidence Act and ask the defendant's advocate, "Mr. Advocate, how do you expect the witnesses to remember such minute details half a decade after the execution of the promissory note?" When the defendant's advocate fumbles to give an answer, the judge may note down that no satisfactory explanation was given. He can instantly come to the conclusion on this issue that the execution of the promissory note is proved. Then issue number 2. Once the execution is proved, there is a presumption under the Negotiable Instruments Act that the promissory note is supported by consideration. Therefore, the judge should turn to the defendant's advocate and ask him to show what evidence he has let in to rebut the said statutory presumption. If the defendant's advocate is able to show that even prior to the execution of the promissory note, the very same plaintiff had filed several other suits for recovery of money against the very same defendant, it would be a strong circumstance to show that the plaintiff would not have lent money to the defendant. At that stage, the judge should turn to the plaintiff's advocate and ask him as to how his client lent the money to the very same defendant who had already a history of defaults in repayment of debts to the same plaintiff, resulting in filing suits against him. If the plaintiff's advocate fumbles, the judge can instantly come to a conclusion that this circumstance is sufficient to rebut the presumption of consideration. This is only illustrative of the methodology to come to instant conclusions, though the actual conclusions might be different depending upon the facts of the case and the psychology of the judge. To avoid a gamble on the psychology of the judge, advanced countries have already have entrusted the power of judging facts to a jury instead of a judge, as I already spoke about it. We may take a long time to reintroduce jury system in India, which was abolished in the 1960s, citing Commander Nanavati's case as the only reason. With such instantaneous conclusions, the judge can dictate the judgment then and there as mandated by Order 20 CPC. He can do it on the bench itself. Of course, the above is a simple illustration, but in more and more complicated cases, the judge is entitled to reserve the matter for judgment. But in most cases, he should pronounce judgment within 30 days as mandated by law. I repeat, the judge is not expected to read the entire case record himself, as it would unnecessarily overburden him, cause fatigue, delay judgments, and ultimately result in coming to wrong conclusions. When a driver, due to excess work, due to constant driving, he comes to wrong conclusions. Instead of pressing the brake, he presses the accelerator, and there is a collision. The same thing can happen to a judge also. I repeat, the judge is not expected to read the entire case record himself, as it would unnecessarily overburden him, cause fatigue, delay judgments, and ultimately result in coming to wrong conclusions. Similarly, when the plaintiff's advocate cites a ruling of the Honorable Supreme Court on a particular point, the judge should note down the ratio decidendi only, and immediately turn to the defendant's advocate to show why the citation of the plaintiff should not be followed by the court. Mr. Advocate, is the citation irrelevant? If so, how? Is it overruled or per incurium? And if so, how? If the defendant's advocate does not give a clear-cut answer, the judge may immediately conclude that the plaintiff's citation is applicable to the facts of the case. It is impossible for a judge, nor is it expected of a judge, to go through all the citations from the first page to the last page to find out whether they are relevant or not. It is the advocates appearing for both the parties to point out how those citations are irrelevant or misquoted. The basis for the conclusion, I repeat, the basis for the conclusion is the representation by the counsel who are responsible officers of the court, and not personal verification of nook and corner of the case by the judge. The judge must extract the maximum amount of data from the counsel by putting the appropriate questions while hearing the argument. The same thing applies while construing documents. The judge should be an active participant and not a mere press reporter to note down whatever is argued by the advocates, however irrelevant it might be. In the Supreme Court and probably in the High Courts, this procedure is being followed to a greater or lesser extent, depending upon the efficiency of the judges. But in the trial courts, where most of the litigation is handled, no judge is following this procedure for fear of offending the advocates and inviting complaint petitions. This is resulting in immense wastage of time and effort on the part of the judge and other advocates who are waiting for their cases to be taken up. Now let me go back to the second issue as to whether the suit promissory note is not supported by consideration. The onus of rebutting the presumption of consideration is on the defendant. The defendant's advocate should be in a position to demonstrate how the presumption stands rebutted by referring to the relevant portion in the record. The judge should control the defendant's advocate. This is important. If he tries to beat about the bush instead of precisely pointing out the relevant material on record, if he fails to do that, the judge must at once conclude that the defendant was unable to rebut the said presumption of consideration. This can be illustrated by giving an example of a physical balance. The judge should initially, suppose this is the balance, the judge should initially start with his mind like a level balance. When the plaintiff goes on adding evidential weights in the form of exhibits and circumstantial evidence, apart from the admissions of the opponent, the balance will tilt on the side of the plaintiff. When the defendant starts putting his evidential weights in the pan on the balance on the other side, and if the evidence is relevant, the balance would slowly tilt in the opposite direction. Whichever side places greater evidence would result in tilting the balance on that side. When there are statutory presumptions, the judge should simply obey those laws by tilting the balance in support of the party who enjoys the benefit of the presumption, and expect the opponent to let in sufficient evidence to tilt the balance, putting appropriate weight. Such intensive grilling of the advocates by the judge is rarely seen in the lower courts these days. Why, I should say that it is never seen. If the counsel deliberately makes wrong statements of fact after warning him for the first time, a report may be sent to the local bar station for the second time, so that the professional colleagues can suitably advise such advocates to mend their ways. He can be proceeded against for contempt by sending a report to the High Court if the advocate does not change his behavior. Complaint also can be given to the bar counsel to discipline such advocates. Why should all these things be done? Because when the counsel deliberately makes a wrong statement of fact, the judge depends upon the statements of the advocates. He is not expected to verify nook and corner of the judge of the record. So when an advocate deliberately does it, not by mistake, deliberately if he does it, this is the procedure. First, complaint to the local bar association, where the colleagues can only advise him. They have no jurisdiction to discipline him. Second time, if he repeats, send a complaint to the bar council and also to the high court to take action for contempt. There are advocates who, due to lack of proper skills of presentation, tend to go on arguing matters on immaterial issues. There are also advocates who, knowing full well that they are beating about the bush, deliberately advance lengthy arguments and cite mostly irrelevant decisions of the High Court and the Supreme Court just to demonstrate to their clients that they have put in a lot of effort in fighting for their clients. The poor judge, especially in the subordinate judiciary, has to patiently hear and note down mostly irrelevant points, resulting in tremendous strain on his mind, apart from leading to wastage of precious time of the court. In the Supreme Court and probably in the High Courts, judges are able to restrict the time taken for arguments. In the trial court, the judicial officers do not have the necessary experience or the courage to control their bar. This video is intended to properly train them in this direction. What happens when the judge omits to notice some important aspects of the case by such hurried hearing? If such expeditious hearing results in injustice due to the possibility of the judge not noticing vital material, both of facts and of law, there is an expeditious remedy called review under Order 47 Civil Procedure Code. The traditional view that reviews can be entertained only in exceptional cases when there is an error apparent on the face of the record, used to discourage advocates from using this provision, and routinely advocates have been suggesting appeals to higher forum. This results in appellate courts getting flooded with appeals. Therefore, the Honorable Supreme Court has liberalized the requirements for entertaining reviews. In Daman Singh versus State of Punjab, please note this ruling, it's very important. The citation is Laws, 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 Supreme Court, 1985-4-40. It's a constitution bench of 5 judges. It was laid down that time of the appellate courts is not to be wasted in determining whether lower court failed to consider a certain point raised by the parties, and review in the same court is the proper remedy. This was also followed in another ruling which is reported in Laws, 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 Supreme Court 2007-12-25. The next question is how to avoid delays in the execution of decrees. The Honorable Supreme Court laid down in a decision reported in